Dear guys and dolls, I formally welcome you to a very, very important engagement in our ongoing journey for understanding different dimensions of the comparative constitutional law, particularly in the context of South Asia. My dear friends, this is an stage where we have been witnessing certain important developments, and these developments have been taking place at international level, at global level, at transnational level, at regional level, at national level. There are certain important facets to this engagement. This is an engagement which is exclusively devoted to the rise of transnational constitutional laws, norms, and sociology of the constitutional law in the comparative constitutional law, structural continuities, and other important facets and transformations, particularly which are taking place in the arena of international law, and that has been very pragmatically influencing the laws and legislations, particularly in the constitutional orientation in our part of the world. Therefore, in this particular engagement, my dear friends, we are supposed to deliberate the rise of transnational constitutional laws, norms, functions, including the approaches which are generally employed. And these approaches over a period of time has also given rise to the contours or the new contours of the political constitutionalism. And another important idea of constitutionalism, which is also known as in some of the geopolitical entities as a theocratic constitutionalism. So therefore, we have to understand what exactly is the function of these approaches and how these approaches have influenced the making of international law within the constitutional structures of national identities or national boundaries. We have to understand the interactions and cross fertilizations among the ideas which have of late started implementing and enriching the idea of comparative constitutional law. Therefore, the domestic transformation of international law is of vital importance, because what we have been witnessing, my dear friends, we have been witnessing the constitutionalization of international law within the national boundaries. We have been witnessing the emergence of certain important patterns of institutional functions, institutional formations through historical junctions in national societies. And this has given rise to certain specific understandings, my dear friends, which have given subsequently rise to a plethora of questions. Questions like, what are the transnational constitutional norms and their reflections and implementation in the constitutional governance in various geopolitical entities at regional level, at national level, or at what we call transnational level? how to address and understand the profits, advantages, merits, and benefits of the rise of the transnational constitutional law. What is the interaction between national and international courts, and how does it facilitate the domestic transformation of international law? How to analyze the patterns of institutional formation through historical junctions in national societies, and how to examine the social processes that has encapsulated national states into a progressively evolving, stabilizing, and facilitating framework for the functions of the state institutions. What distinct, my dear friends, what discernible historical and sociological approaches to examine the deep continuities between national, what we call, constitutional law, and the contemporary models of global law should be undertaken in understanding the idea, or the, this new emergence of the transnational constitutional law. What is the contribution of these developments to sociology of constitutional law and to the sociology of the post-national legal processes, and to the sociology of human rights, law that has to be undertaken? What is self-foundation of social systems and self-contained, or what we call, self impediments, I should say, self constraints of growth, what we call, pressures, so far the constitutional ideas are concerned? What is the distinction between legislative and executive, what we call, authority in exercising and understanding this new development of the transnational constitutional law norms? Should executive and legislative powers be divided, as we have already studied this particular, idea when we were deliberating the idea of, separation of power? So what is the, possibility, what are the, limitations of this kind of a, division? What exactly should be the understanding in understanding this whole, premise? Because when we are, talking of the, sociology of constitution, then the sociology of the constitution, my dear friends, is basically to understand in each and every geopolitical entity role of the state institutions, the institution of tribe, the institution of custom, the institution of indigenous people, the institutions devoted to human rights, a role of the non-state actors in a geopolitical entity. So we have to create some kind of a coordination between the legal coordinates and social coordinates. So these instruments and institutions must be understood in the context of, societal constitution, and that becomes basically one of the, subject matters of the sociology of law, or the sociology of the constitution. So therefore, here German professor, which we have already deliberated, German professor Conrad, theory of, unamendable basic structure of the constitution becomes very, very important. And that is why, my dear friends, we are having different, what we call, constitutions. We are having divergences in the, constitutions in each and every geopolitical entity. Even in the context of South Asia, we are having different constitutions. Afghanistan contemplates the idea of a constitution on theocratic footing, whereas India contemplates a constitution, or India has envisioned a constitution which is exclusively based on secularism. It maintains the republican character of its, polity. Whereas in Pakistan, we are having a different, constitution. where the Islamization drive is reflected in the schematization of the constitutional provisions. So it is the locality and local nature of the certain fundamental principles which basically determines the contours of the constitution. Therefore, question that remains to be answered, and we collectively should try to understand this particular question, and the question is related to what is a transnational constitutional law. This is very, very important, my dear friends. So how we are going to understand this entire what we call understanding regarding what is transnational constitutional law. So therefore, my dear friends, I would like to draw your attention that the emerging field of transnational constitutional law, or ascendance of this particular field, which is known as transnational constitutional law, it basically addresses a certain important questions of constitutional law in a different kind of a contextualization. And that contextualization, my dear friends, is basically domestic specific. It is the domestic specific legal setting that basically contextualized in understanding the idea of the transnational constitutional law. Therefore, this entire what you call idea of transnational constitutional law is basically places entire subject matter of comparative constitutional law as well as comparative constitutional law or international constitutional law in the context with the existing and evolving cultural norms, social norms, political norms within the geopolitical entity. And it also takes into account entire idea of the socio-legal investigations and understandings, how to what we call determine the relationship between law and non-law, and the significance of the legal pluralism that has to be undertaken. Therefore, we can say that the transnational constitutional law considers what role constitutional law and its values likely to play or might play, my dear friends, in shaping and bringing about social and legal transformation within the what we call emerging global socio-economic orders, diplomatic political what we call orders in which non-territoriality or territorially speaking confined spaces of struggle involves the transnational actors and social formation, semantics and dynamics. This is how we should try to understand the whole idea of the transnational constitutional law. It's a very, very important engagement, my dear friends. Therefore, we can say that the transnational constitutional law comes out of constitutional law in a transnational legal context. On the basis of this premise, we can say that the concept of transnational understanding of legal norms is basically an attempt to have some kind of to design and develop a methodological framework to study different tribes, a role of the indigenous people, marginalized communities, children, women, and their human rights, rights of nature as a new emergence in the context of understanding rights of nature constitutionalism, and how this entire what we call adumbration is going to be what we call, understood on the basis of this, idea of, constitutional law norms, forms, actors, functions, processes, legal transformations, legal formations in the internationalization context. We are not here, my dear friends, to position this entire understanding of the transnational law as a distinct legal field. That is not the intention. Intention is, my dear friends, to understand constitutional law norms in a transnational context. Because we have to understand, my dear friends, transnational constitutional law tradition, or you may call it a phenomena, in the context of what we call of, social, economic, political, and now another important addition is also waiting for our consideration, and that is algorithms. So that has to be taken into consideration, and that is going to facilitate our entire understanding of certain important, concepts. The concepts which we have been deliberating, and I have to attend for another, 15 minutes, and that concept is equally important, and that is the concept of the rule of law. And there are other important, concepts, and the concepts like, equality, concepts right to justice, right to access to justice, or right to access internet as a fundamental right. In the light of the, contemporary circumstances, how the contemporary circumstances have been attending this particular, notion of understanding transnational constitutional law, is there any kind of a, what we call, dichotomies which are likely to emerge during our, deliberations, or in the existing what we call, scholarship? We have to identify the dichotomy relating to the comparative constitutional law understanding between global south jurisdictions and global north jurisdictions. So that must also be taken into considerations, without which, my dear friends, we would never be in a position to understand the whole idea of this particular, transnational constitutional law engagement. Because we have to undertake the practical what we call, experiences, how the institutions have been interacting, how the courts have been, behaving, or the highest judicial, legislative, and political establishments in different geopolitical entities have been interacting with each other, or what kind of a response they have been sharing with their, counterparts in different geopolitical entities. So we have to understand, particularly in an age of what we call of, or rather I should say, in an age of the post decolonization, that has to be taken into consideration. Otherwise, we would never be in a position to understand what kind of a, conflictual or differential or other kinds of what we call of, dynamics are, there, or what kind of, semantics are involved. So we have to what we call, locate constitutional law within this particular, framework of, understanding transnational constitutional law, because, my dear friends, it is a very, very important understanding in evaluating the nuances of the comparative constitutional law of SAARC nations. Dear friends, modern nation states have been structured, or in other words, let me put it like this: the modern nation states have structured a multiplicity of contentions specific legal regimes to facilitate collective actions. If you study the majority of the institutions, you will find that majority of the institutions are specific instances of well embedded, well entrenched institutional practices that structures modern international society. The fundamental institutions in a geopolitical entity, or in other words, if I expand this argument, then if you take this argument within the arena of international law, you will find that the fundamental institutions within the rubrics of international law and multiculturalism, my dear friends, basically create a society which is international in character. So, what has been the contribution of international societal constitutional understandings in developing and evolving an international society wedded with or well wedded with the constitutional norms? There are certain important what we call elements to it. There are generic structural elements of international societies, and these generic elements of the international society have been clothed and sheltered under the nomenclature of the customary international law, wherefrom no deviation, no exemption, no derogation is possible. It means, or let me put it like this, the practice of generic, my dear friends, generic structural elements of international societies and the practice and how it is employed, that primarily transcends the changes in the balance of power and in the identification of national and individual interest. Even if their volume, pragmatism, dynamics, density, and efficacy happens to be at variance with each other. Therefore, the modern practice of contractual international law and multilateralism, my dear friends, intensified to a very great extent after the adoption of the United Nations Charter in 1945. But there have been certain important developments, and these developments in the area of international law have been what we call or constructed on the foundation of what we call of institutional principles or other what we call understandings. So that really enriches the whole idea of transnational constitutional law. Let me exemplify my line of argument. You can take the example that the advent of American supremacy or American military might, economic might, diplomatic might, natural resource might. If you take into account all these considerations, you will feel that we have been witnessing a new orientation of international law, which is today known as, in some quarters, as a Americanized international law, Europeanized international law, Chinese international law, or Indianized notions of international law, or South Asianization of international law, Afro Asianization of international law. Because every region, every what you call nation state has been pursuing as well as perceiving international law on the basis of its internal dynamics, based on geopolitical settings, geostrategic capabilities, and internal dictate in the context of social, economic, and political semantics. And that has given rise to certain fundamental principles of a constitutional character. Because it is the fundamental institutions which, my dear friends, differ from one society of states to another society of states. And that is why these notions of a transnational character ultimately enriched the whole idea of understanding transnational constitutional law. Therefore, the governance of the international society, my dear friends, basically based on the institutions of contractual international law and multiculturalism. No such institutions evolved, my dear friends, and we have not been privy to the evolution of these kinds of institutions in the past or in antiquity. I can give you another important example so far the transnational constitutional norms are concerned and their development. If you take into account the emergence or the development of the city states, these city states in the ancient times developed a sophisticated and successful system of what we call of third party arbitration, if you can take this kind of a example. And it was basically the development which ultimately facilitated ordered interstate relations. The institutions which operated in the absence of a body of codified interstate law is best characterized, my dear friends, best reflected as an authoritative what we call trilateralism, bilateralism, multilateralism, or we can also advance examples like the formation of the United Nations organizations. Therefore, there is a significance of the fundamental institutions that has long been, my dear friends, approbated by international relations, international law scholars, or international relations expertise. Therefore, if you can take, I mean, the existing what we call perspectives on this side of the argument, or particularly in the context of what we call international institutions, you will find, my dear friends, that there is a difficulty accounting for either the generic nature of the basic institutional practices or institutional differences between the societies or states. So that particular understanding must not be what we call forgotten. And this has ultimately, my dear friends, given rise to a very, very a different kind of a constitutional usage. And I call this particular usage as constitutional instrumentalism. What is constitutional instrumentalism? It also creates a different kind of a understanding, or you may also call it some kind of a legal instrumentalism. So this legal instrumentalism, it basically, when I use and resort to this kind of a understanding, understanding of the legal instrumentalism, particularly in the modern, contextualization. It is basically an improvement, I should say. It's a kind of a, improvement of certain important norms of the societal behavior, or the fundamental institutions we have, which have been contemplated within the understanding of various constitutions. My dear friends, there should not be any kind of a, instrumental perspective about law. This is the first understanding when we are going to understand the legal instrumentalism, and how this legal instrumentalism has been shaping the entire idea of the modern day constitutionalism. So there should not be, in principle, I am of the view in my individual capacity, my dear friends, that there should not be any kind of instrumentalism in the law, and that must not be employed by the governance rulers or people, because it is the characteristics of the non-instrumental views that the content of law, contours of law, subject matter of law, in a particular sense or in some sense, my dear friends, you know, that law is immanent, that the, process of law making is not a what you call of, matter of creation, but one of the discovery. Law is not the, product of the human will. Law has a kind of autonomy and internal integrity. Law, in some sense, so far my understanding goes, it is objectively determined by the legislative minds. I can give you an example of the medieval Europe. In medieval Europe, my dear friends, you might have studied that the two distinct but, commingled types of law proscribed these what we call, or possessed these characteristics. The first type was law and divine law in the Catholic tradition. For example, 10 commandments, divine and natural law, were thought to be binding upon and to be what we call infused in the positivist law that governed the society. They were pre-given, preordained. Preordained by whom? By God, and were the products of the God's will. And the God's will was, or rather, I should say, the God's will cannot be altered, cannot be changed, cannot be modified by the, human agencies, or by the intervention, or by human intervention. They were objective, that they what he call, constituted absolute moral and legal what he call, truths that were binding on all, providing the content and of setting what he call, limits upon positive law. That was the, contention. But there was a secondary view was also there, and that view is known as the customary view, I should say, or the customary, what you call, law, you may call it. Everybody life during the medieval period of Europe, or in Europe, was governed by customary law, or more accurately, my dear friends, if I'm allowed to say, by overlapping and sometimes conflicting regimes of customary law, feudal laws, law of the, what you call, of I mean, manor, which was very popular, Germanic customary law, that also resides within the rubrics of what you call of the Roman law, trade customs, local customs, or the customary law was said to be, or said to have existed, my dear friends, from time immemorial, or since antiquity. So you can understand, this has been the entire, what we call, journey. So therefore we can say that these intertwined understandings about law, which dominated for at least a millennium, I should say, these were the non-instrumental, so far the core elements of law were concerned, which have ultimately represented a pre-given order that encompassed everyone. But now, if you take this entire, what we call, understanding from the medieval Europe, and try to and graft it in the existing understandings of the constitutionalism, then we find a sense of legal instrumentalism, where the norms of law have been presented, have been misused as an instrument of state. So that is the difference between these two important understandings, of traditional understandings of the common law. What has been in the past, and how the legal regimes have behaved during this particular period, and how this historical understandings of the common law in European nation states, including the United States of America, provide different kind of understandings. Because this reminds me of a very, very important constitutional law, the a doyen of jurisprudence from the medieval, what we call period. I am talking of the Father Fige's characterizations of the traditional understanding of the common law, and that ultimately displays the interwoven inheritance of its in medieval forbearances. So it is very, very important, my dear friends. So if you take this entire journey, it comes to the modern, what we call understanding, where we are trying to encapsulate, appreciate on the critical footing how to understand this whole idea of the transnational constitutional law norms and processes. Then these understandings becomes very, very relevant, because legal instrumentalism has provided and basically founded, or laid the foundation, I should say, of theocratic and political constitutionalism. And this instrumentalization of law, instrumentalization of the constitutional conventions and constitutional norms, to a very great extent has been resulting in some kind of a disservice to the common good, for the common interest, particularly for the humanity which is available on this beautiful planet. But there is a larger perspective, and that larger perspective takes into account, basically, my dear friends, an idea that has to be, what we call understood, that has to be, what we call critically appreciated. And the idea I'm talking of certain important norms, normative understandings, or the transnational normative norms, which are reflected in the constitutionalism. In the constitutionalism, let me put it like this: the constitutionalism of what we call or extra normative law that encapsulates. So what are the transnational normative understandings, normative structure, normative ordering? So that must also be understood, without which we would not be in a position to understand the transnational constitutional, what we call, development. Because a distinction between internal and external dimensions of the law of normative, what we call, ordering, has given or has been what we call, introduced, where we find some important specification with regard to the, respective oriented norms of a constitutional, character, which basically, my dear friends, established the difference between compatibility, transportability, complementarity of these constitutional norms, which ultimately enriched and evolved this understanding, which is known as the transnational constitutional norms or transnational constitutional law understanding. It does not mean, my dear friends, and I'm not, saying that it has created some kind of a what we call hierarchy of norms or hierarchical organizational, what we call, behavior. No, that is not the understanding. Understanding is, if there are, certain important norms which are functioning in India of a constitutional, what we call, footing. So do we have, is there any kind of a possibility to elicit the support for our constitutional understanding from other, jurisdictions? That is the basic idea of, constitutionalization, because the constitutionalization implies a coupling between an internal reconstruction of an external constitutional subject within the constitutional object. So that is the basic premise, and that is the basic understanding. Therefore, I can say, or collectively we may, argue that the major function, or in other words, the pivotal function of nation state law is to facilitate, to enrich normative expectations, to respond to the normative expectations of the people in each and every geopolitical entity. Whereas when we are, talking of the transnational law, my dear friends, transnational law, international transnational law, or transnational constitutional law is primarily oriented towards the establishment of the frameworks of, transferring and mutual, what we call, adaptation. If you take into account this process, my dear friends, not only upholds within interstate frameworks, but also in the area of what we call of, transnational law, where we find a broader category of law which deals with the transfers and adaptations between normative orders, which ultimately emerges on the basis of the cross fertilizations of constitutional ideas. Therefore, we can say that this kind of a, emergence of law can also be understood as a specific form of, transnormative law, insofar it is characterized by a relative structural supremacy of cognitive rather than normative structures of expectations, exclusively or owing their, what we call, legitimacy, as well as their, genesis to its primary orientations towards the establishment of increased mutual adaptability among normative, what we call, ordering of the society. So it is basically the normativity that has, developed certain important ideas which have been, received in the realm of, comparative constitutional law. And therefore, it has further enriched and came out with an understanding which is today known as transnational constitutional law, transnational fundamental principles. If you take into account, my dear friends, the existing perspectives on this particular, idea, then these existing what we call perspectives basically gyrates to understand the relationship between the cognitive and normative dimensions of law, and that too on the basis of the zero sum perspective, where more of one implies less of the other. Therefore the distinction between the cognitive and normative dimensions of law is however logically conditioned by the continued relevance of both the dimensions. So this is how we should try to appreciate this whole understanding, because from a sociological perspective, my dear friends, the relation between the cognitive and normative dimensions of law are moreover characterized by a relationship of mutual increase, where more one of implies none of the other. Therefore we can say that instead of enduring, instead of experiencing, instead of confronting marginalization, normative based legal communication has undergone a reconfiguration which increasingly transforms the normative dimensions of the comparative constitutional law. And this should not be forgotten, because it is the biggest what we call idea that generally enriches the dimensions, purpose, as well as the journey of the idea of statehood. How states are established, that should also be understood, my dear friends. Here another important question that comes to my mind is, and that is relating the sociology of the constituent power, or sociology of constitution. How do you perceive this idea? How many of you have studied the sociology of law? Forget about the sociology of the constitution, but how many of you have studied the sociology of law? Any observation, anybody? No specific question is there from my side.
Yes, sir. We studied Bhagwan Das here, sir.
Yeah, yeah, I know. I got your name. Yeah.
We studied in LLB first year the subject sociology. Its concept all about the socio and life, so related to culture, our society, our culture, our norms, our things happening around our society, like what we are doing for the perspective of our society, either is it right or wrong, either it is beneficiary for our society, or it's only beneficiary for your own interests, or it's beneficiary for your whole country. Like these all are things, sir, I think so, concerned with the sociology, sir.
Hmm. Yeah. Any other observation from anybody?
Thank you. Thank
You're welcome. Welcome. So, dear friends, it has become crystallized or crystallically visible that certain distinctive patterns of the legal norm formation have been developing. And in this development, my dear friends, we find inter and transnational laws which assume effective constitutional status across geopolitical boundaries. For example, in many geopolitical entities, national constitutions have been displaced, changed, repealed. And recently, we have also witnessed in Afghanistan that the existing constitution that was implemented in the year 2004 was displaced by the new regime. But whatever has been the displacement, everything cannot be displaced from the constitution. In the context of Afghanistan, there are certain important norms of a transnational constitutional law character which cannot be, or should not be, rather, I should say, and there is no possibility of depriving people of Afghanistan from those very norms which have been reflected and have become the part of each and every geopolitical entity at international level, at regional level, or in the neighborhood of Afghanistan. Because these norms have developed certain transnational characteristics. And therefore, whenever there is a, any kind of a constitutional displacement, constitutional norms changing, then it has to be what he called, tested on the anvil of the transnational constitutional order. Because this is the emerging constitutional order that has been observed from many standpoints. If you again allow me to contextualize my line of argument, in Afghanistan, if you take some kind of a constitutional analysis of the new, constitutionality range that they have been, propagated while taking some of the important portions to govern the Islamic Emirate of Afghanistan on the basis of 1964 Constitution of Afghanistan, and that was a monarchical, what you call, document. So analysis of the new constitutionality, my dear friends, at one extreme, what we find that from an, though it is having various, dimensions, but if you take into account the body of literature that has been embraced from the global legal system, including the 1964 Constitution of Afghanistan, and how it has been argued by, Kant, Immanuel, Kant, or Kantian world constitution based in obligatory human rights, and at the other extreme, my dear friends, literature denying the persons of anything but jurisprudential pluralism in the legal of the order of modern Afghanistan, and that is exclusively, taken from Islamic jurisprudence. So that Kantian philosophy is not available. That is the, extreme in the modern day Afghanistan. And there is another important extreme which comes from the Islamic jurisprudence. So how we are going to reconcile these two important extremes, that is $1 million question. It has created some kind of a, destabilization in terms of the constitutional, formation, constitution formation. So how we are going to understand this? Because in the context of Afghanistan, my dear friends, there happens to be an increasingly influential line in the field of, constitution making that identifies a transnational constitutional law as arising specifically from legal exchanges which are basically positioned beyond the conventional constitutional sphere of Afghan constitutional law. Therefore, we have to, in the context of Afghanistan, we should not forget the transnational constitutional law norms whenever any kind of a exercise of making a constitution for Afghan society. Because it is important, my dear friends. It is not only important so far the hierarchical norms are concerned, but hierarchical processes of the legal norm construction in the global society also play a very, very important role in constitution making, and this should not be forgotten. Because reconstruction, reconstruction, reformulation, recrafting of constitutional norms, while taking into consideration all the divergent threads which are involved in the ongoing debate, what kind of a constitution should be contemplated for the Afghan society. However, what appears between the line of all these bodies of literature is the sense that the constitutional law or the constitutional form of contemporary society in Afghanistan must reflect a classical sense of constitutionalism or the principles of constitutionalism. And this classical sense of principles of constitutionalism has also been enriched by receiving, facilitating, or by imbibing these fundamental principles of constitutionalism with the norms which come from transnational constitutional law evolution. Therefore, it is commonly suggested, my dear friends, that this constitutional form reflects the diminishing importance, diminishing what we call, waning, significance of the Constitution as one written document or a set of what we call of, documents that originally underpinned by the, popular will of the, people, and that also, prescribes a hierarchy of the legal norms and is strictly very regimentally allocate powers within a national what we call document or national constitution or a national state which itself exercises fixed what we call public control of a particular societal domain. And here, my dear friends, we should not forget the importance of American constitutional exceptionalism, which I have, on earlier occasions, I have also talked of in the class. Because monopolistic, monopolistic or autocratic authority for the production of laws in a particular territory in modern times is not going to be a permanent remedy, a lasting remedy. Therefore, we require the different bodies, a hierarchy of bodies. If we have to develop certain constitutional norms and principles, my dear friends, we do not require any kind of a monarchical state of governance, which of late we have been witnessing in many geopolitical entities, despite the fact they claim themselves to be a state, some kind of a state that basically implements the constitution of the modern day. but that is not the real truth. It's an ostensible truth. Ostensible in the sense where the institutions of the state are basically monopolized, and these state institutions basically derive their legitimacy authority from the cult of man, and the cult of man is equated to be the constitution of the day, then the principle of constitutionalisms are relegated to the background, put at abeyance, and there is no possibility for their implementation, and it is nothing but the instrumentalization of the constitution or constitutional norms, and that has become problematic in societies like Afghanistan. Therefore, my dear friends, above all, different bodies of literature treating the transformation of constitutional law are unified by the fact they basically intuit a decline in the force of the sovereign constituent power and democratic legislative power, more generally as a detriment or determinant of the modern constitutional or legislative or transnational constitutionalism. If you take into account the entire, intellectual, juridical, and judicial autopsy, whatever their, disposition towards the global constitution, we find some kind of a, concurrence in claiming that the existence of a pre-existing constitutional constituent will has been the has been lost in the modern society, and normative what we call expectations deprived from an arena outside a national society, and now prior what we call constraints on legal acts have become the order of the day. So therefore, this has emphasized, my dear friends, we must try to revisit the entire understanding which is available in the arena of American exceptionalism. How this American exceptionalism, my dear friends, have become very, very important in understanding different what we call aspects of our understanding. Almost more than 200 years ago, US Constitution was promulgated, and I must acknowledge this stark reality. This stark reality is not only available in our part of the world, but everywhere you will find it is omnipresent, omnipotent, omnipresent. That Constitution of the United States of America remains the oldest surviving constitutions among all the national constitutional documents. This is the beauty of US Constitution, my dear friends, because we have attributed the words like exceptionalism to it. In this, backdrop, I can claim if I am wrong, you got every right to disagree with me. You can also, propose some of the important what you call, alternative views. in the crystallization of my line of research. US Constitution on many occasions in its historical peregrination, it has been branded as immensely influential document around the globe. And now, my dear friends, it stands apart from the constitutional systems that it previously what we call inspired. The US Constitution is, in many what we call contexts, my dear friends, a global outliner, a global equalizer, a global constitutional roadmap, a global leader in the matters of civil liberties, a global defender of human rights, and many other important roles can also be attributed to this document. This is a document, my dear friends, which distinguishes itself from other national constitutions by its brevity, textual reverence, semantic stability, and important socio-economic omissions in terms of the socio-economic rights. As I have already submitted in my comparative constitutional law of SARC classes submissions, that in major constitutional documents hailing from global north jurisdictions, we find that the socio-economic rights have not been understood in the sense of rights. Rather, socio-economic rights have been crafted as constitutional socio-economic goals which have to be earned by the citizenry. In majority of the situations, it is not obligatory on the part of the nation state or state per se to grant these rights under the constitutions to their citizens. Rather, state is under an obligation to create conditional, conducive, and congenial situations and circumstances within their geopolitical environments to facilitate for earning these socio-economic goals. These differences, my dear friends, have ultimately led many to conclude that there is something different about Americans and their vision of government that is reflected in their very different constitution. My dear friends, the federal constitution may indeed be exceptional, but American constitutionalism is not confined to the text of the federal constitution, nor do the ideas and the practices associated with it. And therefore, with due submission to your understandings, my dear friends, this remains my unqualified understanding. And I would be right in my claim if I'm making this kind of a, claim for your consideration, for your judicial scrutiny, for your juridical, what we call, autopsy, let me say this. And it was the question which many of you have attempted, but not completely, in your midterm examination, that there is a possibility, my dear friends, to have, constitutionalism even in the absence of, constitution. But here I am making a very, pontificated statement. And my constitutional pontification is, constitution or no constitution, and particularly in the persons of a constitution, constitutionalism constitutes a larger than constitution image. It is a fact that the, constitutionalism is evolved out of a constitution. But after its evolution, constitution may be what we call, static in terms of, its semantical understanding. But the constitutionalism that has been evolved out of it becomes dynamic. It does not remain static. It takes into account many other important ancillary aspects, fringe characteristics, vicarious understandings, collateral dimensions, parallel crafting of what we call of, fundamental principles of a transnational law character. Everything is there, and that is why, my dear friends, that is why the Constitution of United States of America has created American constitutionalism exception, or American constitutional law exceptionalism, or American constitutional exceptionalism. Because their orientation of constitutionalism has basically made the Constitution of the United States of America subservient to it. That is the beauty of what I call of its evolution. That is the beauty of the collateral evolution of constitutional conventions in United States of America. And see the journey of, see the journey of this trend of what we call of, constitutionalism. This constitutionalism phenomenon that is reflected in the schematization of the, constitution of the United States of America. That is something which is missing in our part of the world. If I ask you a very simple question at this stage, my dear friends, and the question is, what is the reasons, what are the factors that we have been witnessing on daily basis, on periodic basis, so many amendments in our constitutions? Why? Because in my understanding, you may supplement my arguments. I am of the view that in our part of the world, my dear friends, and because of, our colonial past, we have been amending our constitutions on the basis, number one, that South Asian economies have been the drained economies at the time of decolonization. Number two, in the post, colonial period, our socio-economic and socio-cultural differences delayed the formation of constitutions. Number three, our idea of celebrating heterogeneity and diversity has given rise to political apartheid in South Asia, which has attained and assumed crisis proportions. Number five, after promulgation or after the promulgations of the various constitutions in our geopolitical entities, we have not been successful in ensuring the complete implementation of the constitutional law as well as the constitutional ethos and spirit. Because each and everything cannot be incorporated in the constitutional scheme. Number seven, whatever the constitutional conventions have been developed spontaneously, organically, or silently evolving constitutional conventions. This constitutional evolution of convention or conventions have not been approbated by those very people who have been entrusted with the responsibility for the implementation of the constitutions and their what you call principles. Political differences. Number nine or number eight, political differences ultimately emasculated constitutional conventions in a given period of time. Many constitutional conventions have been dismantled by way of amendments in South Asia. Instead of strengthening them, they have been removed by amending the constitutions or constitutional documents. Next number, constitution as a document, as a basic law of our geopolitical entities, have not been treated as the guiding force, as a roadmap, as a documents that contain fundamental principles of governance, has not been completely adhered to. Rather, the political parties and political parties' constitutions have become the roadmap for governing the South Asian geopolitical entities. So there are as many as, my dear friends, more than a dozen justifications and factors which primarily substantiate the weakening of the constitutional conventions, despite the fact in South Asia the Constitution of India is regarded as the oldest living and surviving constitution. Even then we could not develop, my dear friends, a complete what we call, semantical, textual, logical reverence for the, sanctity of the constitution in terms of, its implementation. This has really created a very, very flabbergasted picture of constitutional implementation in South Asia. But this has not been the case in UK and US, where we find a complete adherence to the constitutional conventions. There is a uniformity, unanimity, and ubiquity about the prevalence, enforcement, and reverence for the constitutional or constitution conventions or constitutional conventions. If there has been an evolution of a constitutional convention in our part of the world, if there is a change of regime, if somebody happens to be a prime minister for 15 years or 20 years in South Asia, then the constitutional conventions, whatever the conventions have been developed and evolved, they are going to be the casualty in the next what I call regime. So that respect, because when we are talking of transnational constitutional law, my dear friends, we are primarily talking of constitutional stability, constitutional continuity, constitutional dignity, constitutional integrity. And where do they come from? They come from transnational constitutional law. Because transnational constitutional law is basically a window that provides us an access to see the forms, to see the norms, to understand the protocols, constitutional protocols, to resurrect the growth, constitutional growth in other geopolitical entities on similar issues or non-similar issues, for the improvement, for the transmigration of constitutional ideas, for the benefits of enriching our own constitutional scheme. That is the beauty of this entire deliberation, and that is transnational constitutional law. So we, under all circumstances, my dear friends, we should not allow any kind of a casualty of constitutional conventions exclusively on the basis of a personal political project. And this is what we have been witnessing in our part of the world. So it is the our collective responsibility, my dear friends, that we must promote the idea of constitutionalism. And that is why American constitutional exceptionalism becomes very, very important. My dear friends, claims about entitlements, rights, and other important features that basically said about American constitutional exceptionalism, however, are generally grounded in the studies of the federal constitutions. Whenever you find time, you must understand this in the federal what we call constitutional understandings. Because we are not supposed to take into account a very narrow or warm view, rather a holistic understandings of American constitutionalism or American constitutional exceptionalism must be taken, because the narrow focus has primarily distorted, concocted our understandings of American constitutionalism and inflated our sense of America's difference. What kind of a difference is generally, presented by this very understanding of American constitutional exceptionalism? If you analyze, and this analysis is very, very difficult to be undertaken, my dear friends, but as an academic, as a student of comparative constitutional law, if you try to assess the last more than 200 years, then we find, my dear friends, Americans have particularly participated in the course of which they have evaluated and updated the choices reflected in the US Constitution. And these endeavors, my dear friends, have long been central to the American constitutional exceptionalism. American constitutional traditions, American constitutional understandings, and any examination, my dear friends, whether American constitutionalism is exceptional by global standards remains incomplete without consideration of state, what we call, constitutions in United States of America. Therefore, it becomes very, very, very important and understandable, my dear friends, that in the context of, American constitutional exceptionalism, we should try to offer systematic, I should say, comparison the US state constitutions to the world, or our part of the world's, national constitutions. We should draw, we should try to draw, my dear friends, on an original, data set, and that must be what we call, based on how our own hand coding of all state constitutions in effect from the year when American Constitution was primarily what we call, adopted. I think, it was 1776. And this must, cover the entire area, I mean the period up to 2022. And thereafter, we should try to contrast it with existing data on national, what we call, constitutions, particularly the constitutions of, South Asia for the same period. That is one argument. My second important argument is, for the sake of, comparison, if we are not in a position to measure more than 2 centuries period of what we call of, exceptionalizing American Constitution, then we can also, measure our 75 years of constitutional existence in South Asia with that of their what we call last 75 years of their constitutional existence. And on the basis of this, 75 years of the constitutional exceptionalism of United States of America must be measured against our 75 years of constitutional existence as an independent sovereign nation states in South Asia. It is going to be a very painful fustigation on my part, without resorting to any kind of a constitutional jabberwockies. That is my well considered opinion. A comparison of the 75 years of the constitutional coexistence on both the sides of the sea, South Asian constitutions might be trailing behind a lot in each and every aspect if they are measured like this. They are not going to offer any novelty, any constitutional innovation. But likewise, we have received many ideas, many constitutional ideas, which ultimately enriched our understanding. And that is why exceptional American taste for constitutional brevity, as it turns out, my dear friends, is confined to the federal document alone. Like most of the world's constitutions, state constitutions are frequently amended, overhauled, and other important amendments are also carried out in their schematization, as we generally witness in the constitutions of the rest of the world. But so far, the federal constitution of the United States of America is concerned, that remains intact. Therefore, textual stability of, of over more than 2 centuries, my dear friends, the federal constitution of the United States of America has become exceptional, what we call, compared not only to other national constitutions, but also to the constitutions of the American 50 states, which are characterized in many ways, my dear friends, by a commitment to progress and change. And at the same time, my dear friends, this should not be forgotten that most of the world's constitutions, state constitutions of the United States of America, contain positive rights, such as right to freedom of education, labor rights, social welfare rights, and environmental, what we call rights. While the federal constitution arguably omits explicit declarations of these rights, they are not foreign to American constitutional traditions or exceptionalism. On all these dimensions, my dear friends, it is the federal level not only that the American constitutional practices appear exceptional, but at the same time, my dear friends, when we include writing and revising or any kind of a revision of the state constitutions in our assessment, it becomes clear that the American constitutionalism is not nearly as distinctive as most of what we call comparative studies and political commentators have suggested. But we have to improve. What is improve? What kind of an improvement should be there? It is the American constitutional brevity, stability, continuity, integrity, which is missing in other what we call constitutions. That really makes the Constitution of the United States of America exceptional, and that is why it is generally attributed and nomenclatured American constitutional exceptionalism. Any question? Any observation? Or you may also offer any comment if you wish. In the context of transnational constitutional law, my dear friends, there are certain important paradigmatic shifts. Because in the 20th century, we have witnessed these paradigmatic fundamental shifts. If at all we are interested to understand the nuances which are involved in transnational constitutional law, we should try to understand these developments. 20th centuries, therefore, have witnessed or has witnessed a movement away from a consensus that constitutions were necessarily expressions of internal socio-political and socio-cultural choices. Choices emanating from unique territorially bounded political communities. And we have to appreciate these choices. Therefore, we can say that the constitutionalism that has also established and given an understanding about the establishment of the different forms of governance, like a presidential form of government, parliamentary form of government, hybridized governance architecture, constitution idea of the constitutional supremacy, and many other important facets of governance. Therefore, constitutionalism intrinsically or internally, my dear friends, directed and focused on legality. Legality of constitutional notions. Therefore, there are certain important, critical questions. The critical questions of constitutionalism were primarily, my dear friends, were primarily relating to the authenticity of the polity, the formal legality of the power of the state apparatus to function, and the conformity of the actions of the state. Conformity of the state means here state institutions, institutions like legislature, institutions like executive, institutions like judiciary, and other many important institutions. These actions of state basically establish the requirements of law. Requirements of law conveys, my dear friends, if we are using this expression, it conveys that there is a requirement that there should be a protection against what we call arbitrary action. Arbitrary action of the state and its agencies. Therefore, result could be perverse, but as long as they conformed to the law, they might be considered legal. Those choices, however, odious, were legitimate to the extent that there was power to what we call enforce them. The locus of what we call, or loci of authority, or the sovereign, or the elections, citizenship, or you may call it the formalistic conformity to process, or conformist what we call process means, I mean here the due process of law. Due process without any kind of a substantive value were the key variables. The verticality of its what we call supremacy in writing and providing a different procedure for any kind of a modification is also one of the most important contention in understanding the evolution or the norms which are emanating from the transnational constitutional law that must also be taken care of. My dear friends, the Constitution of the United States of America expressly insisted on its supremacy in writing and provided a difficult procedure for modification. But if we compare this entire process of amendment and process of any kind of a modification in the constitution in our part of the world, that because of the brute political majority in any of the houses of parliament in South Asia, in South Asian jurisdictions, we can create anything, we can legitimize anything by amending the constitution. And in our constitutional scheme also, my dear friends, we have also incorporated certain schedules, and these schedules status has become some kind of what we call is some kind of a religion. And what is the importance of religion in our part of the world? Nobody can touch it. So if anything is placed in these kinds of schedules in South Asian jurisdictions, then there is no possibility of any kind of a what we call of touching it, amending it, or passing any kind of a reconsideration. We cannot request any kind of a reconsideration whatever has been placed or designated in those very categorizations. But in certain other jurisdictions, a larger perspective is always under scanning. And the larger perspective, my dear friends, is that it is the stability of the constitutional convention. It is the basic structure of the constitution. It is the basic structural attributes of a constitution. It is the constitutional values which have been over the years evolved by different what we call institutions functioning under the constitutional scheme. It is the reception of the foreign law in the context of constitutional norms, like reception of some of the important judicial creativities which have been proffered by the or under the rubrics of European Court of Human Rights and duly what we call critically appreciated by the US Federal Supreme Court, which we have already deliberated. And this foreign law of a constitutional character has also been given some kind of a better treatment in the constitutionalization process in many of the jurisdictions, particularly in the arena of global north. So how we have been tackling these issues in our part of the world? On the basis of our individual and collective political whims and magrings, my dear friends, we have been carrying out those kinds of amendments in the scheme of our constitutions, which basically happens to be circumventing the very constitutional ethos. And because of the political expediency, because of the judicialization of the political premise or the political space and political issues, we are getting certain important decisions from the highest judicial establishment in our geopolitical entities, which happens to be at a variance with the constitutional stability, constitutional brevity, constitutional integrity, constitutional continuity. That has ultimately weakening, emasculating the idea of constitutional conventions. But in the later constitutions, my dear friends, relationship between the law of the constitution and that of other act as an ambiguous. That is why with a power in the legislature, for example, to amend either without much difficulty, other states might express their what we call agreement or disagreement with internal what we call constitutive choices of other states. And this is what we have been witnessing in our part of the world. My dear friends, where the choices were sufficiently appropriately offensive to powerful foreign states in ways that conflicted with the interest of those more powerful nation states, offending what we call nation states might be reduced to either what we call secondary or colonial status. This is what we have witnessed when our part of the world was under the foreign occupation. At that point of a time, constitutions have not been, or the constitutional law of the modern what we call age was not critically appreciated, because at that point of a time, when we are talking of constitutionalism or constitutionalization, we are primarily talking of certain important institutions. As the very outset, I have what we call submitted, and Miss Archana has also put a question in the chat box to this very effect. So therefore, it becomes very, very important, my dear friends, that in the decolonized world led by American academics and political elites seeking to remake a world upended by a half century long war in which most political and powerful relationships had been affected. And by the middle of the 20th century, my dear friends, there emerged the notion, which has been very beautifully articulated first successfully in the German and Japanese post-war constitutions, that not all the constitutions were legitimate. It is basically the constitutionalism that required more than the enactment of the written constitution, even one concerned with the formal protection against arbitrary use of power. And use of arbitrary power, that has been what we call branded, my dear friends, as one of the most important what we call anathema to the idea of constitutionalism per se. Legitimate what we call constitutions shared a number of the common characteristics that establishes their transnationality, or the transnational characteristics of their constitutional law. And these common characteristics, my dear friends, were both procedural, against arbitrary use of state power, and substantive, the limiting the sorts of policy choices states could make in constituting its governance or government, or exercising any kind of a governance structural what we call power. And these procedural and substantive norms were in turn an articulation of a higher law that comes out of what we call of community of nation states. And that community of nation states, my dear friends, basically establishes the idea of transnational constitutional norms, processes, and other important dimensions, which remain to this date, my dear friends, very, very dynamic. And their dynamism is likely to further enrich this ongoing debate. And this is how we should try to understand this whole idea of transnational constitutional law, because we should not forget that notion of a higher law, my dear friends, notion of a higher law of any kind of a geopolitical community of nation states, that primarily reflect a global command consensus, some kind of a common consensus. And that is further evidenced in common practice of the international agreements. Notion of higher law suggested a necessary universalism with roots in both natural and religious law. Therefore, constitutionalism in the 20th century was tied to the construction of a collective and international society of states that ultimately resulted in the evolution of the transnational constitutional law. And this transnational constitutional law presented us the universality of certain important norms, regulations, processes, certain important what we call common forms of governance, which are reflected in the separation of powers, in the form of governance architecture, and other forms of what we call of human realizations, and the supremacy of the constitution with the supremacy of human rights, or with the centrality of human rights in our schematization. So thank you very much for the day. I will continue, and I will request you again, if there is a boycott of the classes on the next what you call turn, then my request is a standing request, my dear friends. And with this, my dear friends, I will request you again, if it is possible, even on Thursday, I would like for an go for an online class. If there is no boycott of the classes, definitely I would be engaging you offline in the classroom itself. So thank you very much for being with me and providing your valuable time. So thank you very much. Thanks a lot.
Thank you, sir.
Thank you.
Have a good day, sir.
Yes, same to you.
Thank you, sir.
Same to you. Same to you. Thanks a lot. Bye bye. Take care.
Bye bye. Take care, sir.
Yeah, please do take care of your health. Yeah. Thank you. Thank you very much. Bye bye.